Good evening and welcome. Thank you for tuning in. My name is Samilano Simalinog, and this is Legal Basics for Teens. Today's top story, the right of freedom of speech in the First Amendment. We hear people say a lot, both online and in person, that they have the right to say whatever they want because they have the right to freedom of speech. But what exactly does that mean? And is it true? Is all speech protected? And how do we decide? Let's first define what freedom of speech is. Freedom of speech means the free and public expression of opinions without censorship, interference, or restraint by the government. Now let's take a look at where this right originally comes from. The First Amendment in the Bill of Rights of the US Constitution reads, quote, "Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people to peaceably assemble, and to petition the government for a redress of grievances." Notice again, quote, "Congress shall make no law abridging the freedom of speech." Now remember that Congress refers to legislative bodies or any governmental body that creates laws for the citizens. At the federal level, this includes the Senate and the House of Representatives. The Constitution says that the people who make laws are not allowed to make laws abridging or limiting free speech. It seems simple enough, right? It is important to note that freedom of speech prevents only government restrictions on speech, not restrictions imposed by private individuals or businesses unless they are acting on behalf of the government. Free speech also includes free expression, which is also known as symbolic speech. Symbolic speech is any nonverbal conduct intended to convey some kind of message. This includes destroying objects, like flag burning to make a political statement, clothing with a symbolic message, silent marches and sit-ins, body language, computer code and software, and more. Congress cannot make any law limiting our right to do these things. But if that's the case, why is it that a public school, which is acting on behalf of the government to educate children, can make rules about students' speech and expression? How come we can get detention, or even suspended, for saying, doing, or wearing certain things? Shouldn't freedom of speech protect our ability to express whatever we want in the classroom? Joining me now live in the studio to explain more about students and free speech is Rutgers Law School 2L Rohan Suvarna. How are you, Rohan?
I'm good, thank you.
So tell us a little bit about what free speech laws look like as far as students in school are concerned.
Free speech in school is a tricky thing, but it's certainly something that's real. It may not feel like it sometimes, but the Supreme Court has held that students do have a right to free speech that's protected even while they're in school.
And that's speech at all times protected, correct?
Well, not exactly. There are a couple cases that explain when the right to free speech in school is protected and when schools are allowed to enforce rules that limit certain types of speech. In 1965, for example, some students in Des Moines, Iowa, decided to wear black armbands to school in protest of the Vietnam War. And the school created a policy that stated any students wearing an armband would be asked to remove it immediately. Students that were violating this policy would be suspended and allowed to return to school only after they agreed to comply with the rule. Three students in particular, actually, their names were Mary Beth Tinker, Christopher Eckhart, and John Tinker, were suspended after they wore the armbands anyway and just violated this rule. It eventually reached the Supreme Court, where the court decided in a vote of 7-2 that school administrators would have to demonstrate constitutionally valid reasons for any specific regulation of speech in the classroom. They said that students and teachers do not shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. And that's an exact quote from the opinion, which really just means that people don't lose their constitutional rights once they walk into school.
Wow. So you're saying that the court decided that schools can't censor any speech by students?
So no, what they said is that for school officials to justify censoring speech, they must be able to show that their action was caused by something more than a mere desire to avoid the discomfort and unpleasantness that always accompanies an unpopular viewpoint. That the conduct that would materially and substantially interfere with the requirements of appropriate discipline in the operation of the school. A student expressing an unpopular political view that might cause debate, that can't be censored. But any speech that could have the potential to cause disruption can be restricted by the school. Like wearing black armbands, for example, that's not disruptive. Even in the form of a protest, that's not, disruptive according to the Supreme Court. So the court ruled that, that wearing an armband basically fell under free speech, and that's actually what gave birth to what is known as the Tinker test.
In other words, the Tinker test asks, did the speech conduct in question materially and substantially interfere with the operation of the school? And if yes, and only if yes, the school can restrict it, right?
Yes, but the ruling in that case was narrowed with a couple of cases later on. For example, in 1986, a student in the Bethel School District made a speech full of sexual innuendo during an assembly. The Supreme Court ruled that vulgar language in a school setting was not constitutionally protected by the ruling in Tinker. That case was Bethel School District versus Frazier. The court agreed that adults who use similar language to make a political point are protected by free speech, but not students in a public school. Now, that's an important distinction to make there. And in 1988, a high school principal blocked the school's newspaper from publishing 2 articles about divorce and teenage pregnancy. In that case, the Supreme Court ruled that the principal's editorial decision was justified because the paper was school-sponsored and existed as a platform for students in a journalism class. That case was Hazelwood versus Kohlmeyer. But in all of these cases, the court's findings more or less boil down to this. Any speech that causes a substantial disruption or infringes on the rights of other students can be restricted.
All right, thank you very much. So just to be clear and recap a little bit, students have the right to freedom of speech, even in a school setting, unless the speech materially and substantially interferes with the school and discipline, the speech includes vulgar language, or if censoring the speech is reasonably related to legitimate pedagogical concerns.
Correct. Thank you for having me.
We now go live to our reporter on scene at Juneau Douglas High School in 2002. Reporter Delilah Hayden of Rutgers Law School 1L with the story.
Thanks, Sam. On January 24, 2002, the Olympic torch was passing by the Juneau Douglas High School in Alaska as part of the Winter Olympics torch relay. Students and teachers at the school were allowed to leave class to watch it pass by. Student Joseph Frederick and his friends stood on the sidewalk across from the high school, off school grounds, where they held up a banner that read "Bong Hits for Jesus" in front of the television cameras. Principal Morris saw them, ran across the street, and asked them to take the sign down. When Joseph Frederick refused, Principal Morris seized the sign. As a result of the incident, Joseph Frederick was suspended for 10 days.
Wow. So I have some questions. We just learned that free speech is protected for students unless it's disruptive, vulgar, or there are teaching concerns. Were any of those present here?
It's a great question, Sam. Well, there was no sexual innuendo or swear words on the sign, so there's no vulgarity. And this was outside of the classroom and not related to an educational setting, so there doesn't seem to be a pedagogical concern. Sorry. As for disruptive, students on scene at the torch passing reportedly threw Coca-Cola bottles and snowballs at each other, and some students got into fights. But all of that happened before the banner was displayed, so it couldn't have been caused by the banner, and Joseph Frederick and his friends were not involved in any of those disruptive actions.
So how could the principal take the sign away?
Well, Joseph Frederick also had the same question. When Principal Morse took the banner away from the students, he asked, "What about the Bill of Rights and freedom of speech?" She told him that the banner violated the school's policy against displaying offensive material, including material that advertises or promotes drug use of illegal drugs. So the principal grabbed it and crumpled it up. When he was suspended, Joseph Frederick spoke to an assistant principal. He says that assistant principal told him the Bill of Rights does not exist in schools and does not apply until after graduation. Principal Morse confirmed that the assistant principal made some remarks to the effect that students do not have the same First Amendment rights as adults.
I see. And what did the Supreme Court have to say about all this?
Well, in this case, Sam, the Supreme Court sided with Principal Morse and said the school did not violate Frederick's First Amendment rights.
But why?
The court came to three main conclusions. First, the phrase "bong hits for Jesus" might be interpreted as trying to convince people to do illegal drugs. Second, discouraging drug abuse is an important congressionally mandated role of public schools. So any speech encouraging students to do illegal drugs interferes with the school's education mission. And number three, because Frederick attended an event that occurred during school hours and was school sponsored, he was subject to district policy and rules of conduct, even if he was across the street and not exactly on school property. So, because the First Amendment does not protect pro-crime student expression at school events, it was constitutional for the principal to take the banner. Reporting live, this has been Delilah Hayden with Legal Basics for Teens.
And now our meteorologist has more.
Today's meteorologist is Rutgers Law School 1L, Adam Frank. Take it away, Adam.
Thank you, Sam. It's important to note that not all speech is protected by the First Amendment, even for adults outside of the classroom. We don't have time to get into all of them, but let's look real quick at a few exceptions. The right to free speech does not protect fighting words, which is speech that tends to incite an immediate breach of the peace by provoking a violent reaction. Fighting words include any personally abusive word that is directly insulting to the hearer that an average person would know might start a physical fight. It also does not protect against true threats of violence, which is speech directed at a person or group of persons that has the intent of placing the target at risk of bodily harm or death. False statements of fact, in other words, lies. This includes fraud, which is lying to gain an advantage, libel, which is a lie to make someone look bad that's published in writing, and slander, which is a lie to make someone look bad that's spoken to a third party. Child pornography is also not protected. And finally, we have incitement, or speech advocating for the use of force to produce lawless action, which is also not protected. Back to you, Sam.
So to recap, free speech is a protection granted to you by the First Amendment of the Constitution that says you cannot be punished or restricted in what you say or express symbolically. Your free speech rights still exist when you're at school, but only as long as your speech is not disruptive, vulgar, or concerning pedagogically. Free speech is not an absolute right, because there are many exceptions for which you can still face real consequences. Still to come ahead, your regularly scheduled law class. What will you learn today? Be sure to show respect to your teachers and fellow students, and remember, you never have to talk to the police without a lawyer present. Thank you for joining us and have a good day.